House Regulatory Reform Committee will please come to order. Clerk, please take the roll.
Chair Aragona.
Here.
Representatives Fairbairn.
Here.
Wozniak.
Here.
Wenzel. Tisdale.
Here.
Hoadley.
Here.
Nyer.
Here.
Regas.
Here.
Thompson. Linting.
Here.
Liberati.
Here.
Carter.
Here.
Whitsett. Whitworth.
Here.
Neely. Devendorf.
Here.
Grant. Mr. Chair, you have 12 members present. You do have a quorum.
Thank you, Madam Clerk. And Representative Regas moves to adopt the meeting minutes from last meeting without objection. So ordered. Thank you, everybody, for being here today. I think this is going to be a fairly short committee. We do have a couple of bills up. One on bottle deposit credit, which is demonstrably similar to a previous bill that we've already had a hearing and voted on. We also were going to have a package of bills to vote on offered by Representatives Begole and O'Neill regarding transfer of title. However, we're going to pull those back because they do need a little bit more work, so we'll be voting on those next week. And then we also have a package of bills from Representatives Fairbairn, Hoadley, and Liberati regarding realtor disclosures resulting from a recent court case. And then finally, we also have a bill offered by Representative St. Germaine on forms of ID for purchasing alcohol, which is very befitting for this committee. Without further ado, I think we are going to vote on House Bill 5517. Before we do, I want to read in a couple of cards. Looks like Nick Cronsbean from UBCR does not wish to speak but does support the bill. Chuck Regal from Tamra does not wish to speak, supports the bill. Tom Emmerich from Shupan does not wish to speak, supports the bill. Michigan Beer and Wine Wholesalers Association does not wish to speak, supports the bill. And then the Michigan Beverage Association, soft drinks, does not wish to speak, is neutral on the bill. I think that is it for that, right? Correct? Okay. All right. Representative Hoadley moves to report House Bill 5517 with recommendation. Clerk, please take the roll.
Chair Aragona.
Yes.
Representatives Fairbairn.
Yes.
Wozniak.
Yes.
Wenzel. Tisdale.
Yes.
Hoadley.
Yes.
Nyer.
Yes.
Regas.
Yes.
Thompson. Linting.
Yes.
Liberati.
Yes.
Carter.
Yes.
Whitsett. Whitworth.
Yes.
Neely.
Yes.
Devendorf.
Yes, and not Neely. Not Neely. Take hers off.
Oh, okay.
Because she's not here.
So Whitworth, yes. Neely. Devendorf.
Yes.
Grant. Mr. Chair, you have 12 yeas, 0 nays, 0 passed. The motion prevails.
Thank you, Madam Clerk. Next, we are going to move on to House Bills 5227, 228, and 229. I'm going to invite up Brian Westron. He wishes to speak in support of the bill from the Michigan Realtors, and he will be joined by one of the sponsors of the bill, Representative Fairbairn.
Well, good morning, members of the committee. Thank you, Mr. Chair. It is my pleasure to come before you this morning, along with Representative Hoadley and Liberati. We're excited to sponsor these bills, speak to you about them. They're about agency disclosure. These bills will amend the Michigan Occupational Code, updating language specifying disclosure requirements relating to agent-client relationships. House Bill 5227 will eliminate implied agency, requiring a written buyer-agency agreement to establish an agency relationship and allowing consumers greater latitude in determining the buyer-agency situation that is right for them. House Bill 5228 clarifies certain provisions in the Agency Disclosure Act concerning limited brokerage services, and House Bill 5229 makes additional amendments to the code to preserve sellers' and lessors' ability to enter into limited services contracts. Though Michigan has long had some of the strongest consumer protections relating to required disclosures, the 2024 federal antitrust settlement in Burnett versus National Association of Realtors spurred legislative activity across the country to enhance disclosure requirements in many other states. These bills will help to ensure that Michigan's statutory language aligns with that of other states, and we continue to be at the forefront of protecting consumers and ensuring that there is a clear understanding of the extent of services and the responsibilities of real estate licensees with whom they are working. With us today is Brian Westren, General Counsel for the Michigan Realtors, and I would ask that he offers a little more detailed explanation on these bills.
Thank you, Representative. One of the biggest issues that we've seen in the wake of the Sitzer-Burnett settlement is confusion in the space where buyer agency exists. So we've got buyers obviously out there looking to be competitive, and historically they've been able to work with a buyer brokerage, but not necessarily in a formalized capacity out of the gate where they would sign into a written agency agreement. Oftentimes they would do, as we often say, sort of speed date and try and find a buyer agent that works specifically for them, but it might be in a customer service capacity. So they may work with a buyer agent in a situation where they don't formalize agency. But as the representative said, we also have implied agency in our state, which means that if you are engaged with a licensee as a buyer agent, but you may think that you're working with them as a customer, the actions of the parties matter. And under this legislation, it would make it very clear that you do not establish agency and you do not have all the fiduciary duties until you have that written agreement in place. That's important for a from a brokerage perspective, in the sense that brokerages need to have that risk reduction strategy to make sure that they are not engaging in any behaviors that trigger agency. But it's also really important from a consumer perspective, because many consumers will want to figure out whether they actually want to engage in an agency relationship, not based on their actions, but based on the signature on the four corners of the document. So ultimately what this does is it treats the buyer side of a transaction just like the listing side of the transaction, where you enter into a listing agreement, you have a written agreement that spells out the actual expectations of the parties, not only financial obligations, but also the fiduciary duties and services that you're agreeing to. That would now be placed squarely on the buyer side as well, and make sure that that formality observes. But if there are any questions, we think that this really drives home the point that consumer protection and brokerage risk reduction really kind of coexist here, and this will be an important way to move our industry forward.
Great. Thank you for that testimony. We're going to go to some questions from the committee now. Representative Wozniak.
Thank you, Mr. Chair. Brian, could you explain the history of how buyer's agency, seller's agency came about, and the confusion that always existed with buyers and sellers?
Absolutely. So pre-1994, we existed in a world where real estate agents essentially all operated in the space where they represent the seller. So we called that sub-agency. And around that time, you would have buyer representatives, but those buyer representatives ultimately were contracting with the listing firm and the seller, so that the understanding that you would have really any fiduciary duty or representative capacity in the buyer side was not only confusing to the buyer, thought they had an agent, but that agent was actually working on behalf of the seller. And ultimately that brought about a change in the industry where we clarified that there are listing side agents and there are buyer side agents. Unfortunately, oftentimes, with that change, practices were not necessarily clear, because you did not always have to have a written agreement in place to evidence agency on the buyer side. So what this change would do is ultimately create that level of formality that you have on the listing side, and make it very clear, especially from a legal perspective, that buyers who want representation have a written agreement that spells out the fiduciary duties, that spells out all the expectations that they would have under that contract. So as Representative Wozniak is inferring, we have sort of had a long history of the buyer is represented, but where do the fiduciary duties exist? Is the buyer actually getting the same level of treatment that the listing side would get? And ultimately, I think this makes it very clear that the contract matters. The contract spells out those expectations, and it should really make that buyer more comfortable with what they've contracted for, and it certainly makes the brokerage more comfortable as they decide whether or not they're going to have buyer representatives or just simply listing side representatives.
And these amendments help level that playing field even more.
Yeah, I think the amendments to say level the playing field, I think really just make the optics clear that you've got buyer side representation that's clearly spelled out, and then you've got that listing side. But you also have the option from a consumer's perspective where if they want to operate as a customer, they can do that up until the point of submitting an offer to purchase. If you're using a licensee to do that, there has to be agency established.
Great explanation. Thank you.
Can you explain real quick, as a result, after the court case that you had mentioned, what would be the consequences if we did nothing in Michigan, if we made no updates to the code?
Yes, so with implied agency existing in Michigan currently, you have the possibility, and this is going to get a little technical, but in Michigan we have two different agency models. We have offices that are traditional agency, where every agent in an office has a relationship with a client that's under contract. And then we also have designated agency offices in our state. So that means that a brokerage can designate specific agents to represent specific clients, and that the supervisory broker is the only party who has that sort of global agency with all the clients. What the case brought about was ultimately a requirement that if you are going to work with a buyer brokerage and a buyer, working with a buyer triggers the need to have a written agreement. So if I'm touring a property, I have to have a written agreement in place, and that can be either customer-centric or it can be agency. And without these changes, if you have a customer-centric relationship, but the behaviors of the parties sort of evidence agency, like I'm giving you the full complement of fiduciary duties and services that I would otherwise give if I had a written agency contract, that can trigger a real issue not only for the consumer, who doesn't truly understand exactly what services they're receiving, but also that brokerage that may be, as I mentioned, a designated agency firm, and that designated agency firm requires written agency contracts. And if I'm just holding up a customer agreement, that could blur the line and create a real problem for that firm, where it sort of blows up the model. And then, of course, you have instances of what we call non-consensual dual agency. And the consequence of that is not only mayhem in the transaction, but also potential forfeiture of compensation. So.
Thank you. Okay, and is there any difference or applicability difference with this code between the residential and commercial sides of real estate?
So this is very specific to residential transactions.
Okay.
So you'll note that the references to section 2517 in the code, that mirrors the definition for residential transactions. So commercial, oftentimes, especially from the buyer side, involves quite a greater degree of sophistication. You're going to have attorneys involved, and the agency side of that, while it's important to have all the parties aware, what this does is make it very clear that in a residential transaction, if you are going to submit an offer on behalf of a client, you have to have that agency established, but only in residential.
Got it. Thank you. Okay. Any further questions from the committee? Seeing none, thank you very much, guys.
Thank you.
Appreciate it. All right. Next, yes. Mac Jones from Laura does not wish to speak, but is neutral on House Bills 5227, 28, and 29. And then the Michigan Society of Professional Engineers would like to slip in opposition to House Bill 5229 only. Okay. And then I also want to go back to House Bill 5517 that we just voted on. Looks like there was a bit of a clerical error. The Michigan Beverage Association, Soft Drink Association, I mentioned that they were neutral. They are actually in support of the bill. All right, next up, we have House Bill 5122, offered by Representative St. Germaine. I'm going to ask that she come up. Whenever you're ready.
Thank you. Well, good morning, Chair and members of the committee. I appreciate the opportunity to speak today on House Bill 5122. This bill is a simple, common-sense update to Michigan's liquor laws that modernize how adults can legally verify their age when purchasing alcohol. But I have to be honest with you. These days, I rarely get asked for ID to purchase alcohol. But when I do, it is a wonderful, wonderful thing. House Bill 5122 expands the types of acceptable photo ID that can be used to verify age for alcohol purchases. Many businesses feel constrained to accept only a limited set of IDs, even when a customer clearly has a legitimate, government-issued photo identification confirming they are of legal age. This bill simply updates the law to reflect real life today, while still maintaining responsible safeguards for age verification. It doesn't weaken age verification. It is about making the rules clear and workable for businesses. And from a business perspective, this matters. Restaurants and hospitality establishments rely heavily on alcohol sales. In fact, they generate roughly 70 to 80% profit margins as compared to food at only 10 to 15%. More completed sales and less confusion at the point of service is a win-win for both the customer and the restaurant business community. A restaurant can focus on serving customers, not second-guessing compliance. This legislation simply provides clarity, flexibility, and modernization while continuing to ensure alcohol is sold responsibly and only to those of legal age. Finally, I just want to make a note that we have been communicating with Laura regarding this legislation, and we are working together through some minor technical tweaks. Thank you. That's all I have, and I welcome any questions.
Great. Questions from the committee. Representative Regas.
Thank you, Mr. Chair. Thank you, Representative, for your testimony, and I do really like this bill. My question, however, would CPLs be included in this?
Good point. If you look at a CPL, it has an emblem. Mm-hmm. It is a card, so hard to duplicate. It's got the photo and the identification. So a great example, which is kind of what brought this legislation to fruition.
Okay.
Yep.
I mean, I've had to use my CPL in a pinch, and you know how it is.
Right.
When your wallet's full of a lot of other things. I just grabbed my CPL, and I was able to use that as a regular ID. I just want to make sure that would be a possibility.
Right. You know, sometimes we lose our driver's license, and we have other forms of identification that can clearly indicate our age. So not my age, but young people.
Well, yeah, I would not want to say that I couldn't find my license, so I use my CPL because we all know that's not proper. But just in a pinch.
Yeah, good question. And I've spoken to many restaurant owners, and that's what they're looking for. They want to make that sale, but they also want to safeguard their business. So something on a card rather than paper.
Yep. Okay, good. Thank you.
Yep.
Any further questions from the committee? Representative Nyer.
Thank you, Chair. Would this also include tribal IDs?
Yep. Absolutely. Yep. Good point. I've never seen one, but yes.
Yeah. And how do you know whether or not they use a standard protocol there, so that way it's, be that we have so many different tribal nations in the state? Is there a standard form that they use that sort of reconciles with the state and federal ID system?
I'm not sure with the tribal ID, so.
All right.
Yep.
Thank you.
Any further questions from the committee? Seeing none?
Thank you.
Thank you very much, Representative. And that concludes our bills for today. Representative Linting moves to excuse absent members. Without objection, so ordered. Seeing no other further business before the committee, we are adjourned.